Just one little quick note. When I asked Jay to come and speak, I was very impressed with their law firm and what they did. And so they have represented many Indian tribes for quite a while and have an amazing amount of information. So Jay, take it away.
You, Esther, and thanks to Cottonwood for hosting us, and thanks for all of you to come out. I'm always happy to talk about water, and I could spend, you know, 3 days talking about it. So I'll try to contain myself so we can get out of here. Is this better? Okay, directional mic, got it. Okay, so my name's Jay Tomkus. I work for a small firm called Montgomery Interpreter. Primarily, we represent Indian tribes on water issues. We're also general counsel to the Intertribal Council of Arizona and the Intertribal Association of Arizona. And those organizations represent 21 out of 22 federally recognized tribes in the state. So our experience comes from Indian country, and we talk frequently with other tribal attorneys on water as well. So I'm going to present first on Indian water rights sort of generally, give you some background on Federal Reserve rights, and then, there we go. And then I'll talk a little bit about the Yavapai Apache Nation. Our firm represents the Yavapai Apache Nation on water matters, and we represent them in the general stream adjudication. I'll talk a little bit about why the nation is in the general stream adjudication, how federal reserved water rights play with state water rights, and what it means really locally here. And then talk a little bit about the nation's efforts to settle its water rights claims as well. So I want to start sort of basically with what a federal reserved water right is. And we've, Sarah and Greg gave a great discussion about the state-based system for appropriating water and state water rights. Federal reserved water rights are different. They are federal rights that derive from some act of the federal government, whether it's Congress, whether it's an executive order, or some other action. And it's important particularly to note that they are not state-based water rights. They're not subject to the state requirements of state, the same requirements of state law. And so when we're thinking about state-based water rights versus federal water rights, there's some inherent conflict there, right? Because a federal reserved water right didn't need to go stake a claim pre-1919 or file a notice of appropriation after 1919, but they're still drawing water from the same source. And as Greg said, and the purpose of the general stream adjudication is really to get all of those water rights on a big chart, right? And have all of the different attributes for those water rights listed so everyone knows who was first, who gets the water if there's a shortage, and those questions, right? Well, state water rights and federal water rights draw from the same sources, and so they have to be on the same chart. And so because of that, we have sort of this inherent conflict between federal law and state law, but they really can be read together. And so I wanted to sort of flesh that out a little bit better. So the first case is a U.S. Supreme Court case called Winters, and sometimes you'll hear about federal reserved rights as Winters rights. And what that means is it refers to this specific case where there were two Indian tribes put on the Fort Belknap Reservation on the Milk River. And these were tribes that traditionally sort of had very large areas, right? And they were taken from those large areas and put on this reservation. And the goal of the United States was to say, okay, we understand your traditional way of life was one thing. They're put on the reservation, and they're put there specifically to create a tribal homeland for those tribes on the reservation. I have a bit of a tickle in my throat, so I have a cough drop. I'm sorry if you hear that. And so you can see down on the bottom there, they're on the river. They're building this new way of life for the tribes. And the goal was to create an agrarian lifestyle. So instead of hunting migrating herds as they had done traditionally, right? They're put on a smaller piece of land and essentially told to grow crops in a traditional Western style, and they start doing that. The problem then comes when settlers come and start diverting water upstream. And so the question before the U.S. Supreme Court was, well, when when the United States set apart this parcel for the tribes, what did they do? Did they also reserve enough water to carry out the purpose of that reservation? Remember, the purpose was to create this permanent tribal homeland. And the Supreme Court said, yes, that's exactly right. That's what the United States did. When they set this aside, if there was not some action protecting the water rights, it would defeat the purpose of that reservation by Congress. And so the intent of the United States would be frustrated in that. And so this is really the basis of federal reserved water rights. The United States does some act to reserve a parcel of land, some area of land for a purpose. And federal reserved water rights say whatever the amount of water necessary to meet that purpose is what that federal reserved water right is. And that's it. And so the question really becomes, particularly with federal reservations of land that are not for Indian tribes. For Indian tribes, it's generally, and the Supreme Court has said the purpose is to create a permanent tribal homeland. But if you're looking at other reservations of lands like the San Pedro Riparian National Conservation Area, the struggle really there is what is the purpose and how much water is necessary for that. And that's a case actually in front of Judge Brain is currently. So I did want to put up this chart, and I think Sarah had a very similar chart up as well. But I want to explain sort of what we're looking at. So because the purpose of Indian reservations is to provide a permanent tribal homeland, and the Federal Reserved Water Rights Doctrine says that when Congress acts, the moment that Congress acts, it creates this water right. The priority date for all these federal reserved rights is the establishment of that reservation, whatever the act was, whether that was an act of Congress or a treaty or an executive act, right? And so if you look on the chart here, you'll see the reservations for the tribes in the state. And it's really hard to see, so I apologize. But if you start looking at dates for these, you'll see some pretty high early priority dates, right? You have Salt River, Pima, Maricopa at 1879, Navajo, 1846, I think that is. Yeah, so generally early priority dates. Camp Verde Reservation for the Yavapai Apache Nation is 1914. And so the federal reserved water right dates to that time. That's the priority date for it. And if you're thinking about how this fits in that big spreadsheet of prior appropriation, those are the dates that slot in there, right? And the quantity is the amount necessary for a permanent tribal homeland. So Indian tribes can also hold other sorts of water rights. One in particular I'd like to talk about is Aboriginal rights. These are sometimes called Winans rights. And they're different from Winters rights because Winters rights are created when the federal government does something, right? And Aboriginal rights, Winans rights, are instead rights that are reserved by the tribe and not ceded to the United States. And so in this case, Winans, it's the Yakima Nation, which had fishing rights to its usual and accustomed place. And what the Supreme Court said in that case was that because the tribe reserved to itself in a treaty those rights and never ceded them to the United States, that it had the right to carry out that fishing and all of the necessary rights implied with that. So the ability to access the river for those fishing rights. The goal, well, how this relates to water is not necessarily for fish in Arizona, right? This is the Columbia River and fishing is different there, right? But instead, it is to say that if a tribe is in its Aboriginal area, where it's always been, and it's always carried out some water-intensive task, whether that's irrigation or for cultural purposes, then it still has those rights until the United States takes them away. And so tribes will assert Winans rights as well. Tribes can also acquire state-based rights or ditch rights if they acquire parcels that have previous state-based rights. And then that becomes part of the tribe's water portfolio. So that's sort of the real quick version of federal Indian law or federal water law. I do want to talk about how federal law interacts with state law, where there's that conflict, right? And as Sarah and Greg and Natalie all noted before, and I guess I'm following Sarah's advice that you're going to have to hear things a lot of times to pick it up. So I apologize for being repetitive. But Arizona has a bifurcated water system, so groundwater versus surface water regimes, right? And they've done a great job talking about what that means. Federal law does not recognize a bifurcated water system. And what that means is that for federal reserve rights, including in Arizona, where there are bifurcated systems, assertion of a federal reserve right does not recognize that bifurcation. And this came out of another U.S. Supreme Court case called Capert versus the United States. And it's an interesting story. So the federal government set aside an area of land to preserve the natural resources in it. Included in that was a place called Devil's Hole. Devil's Hole is essentially an underground lake, okay? And in the lake, there is a particular kind of fish that's only found there in the world, the desert pupfish. It's blind, kind of ugly, but it's only found there, and it only breeds on like the specific shelf within Devil's Hole. And if the water were to drop below that shelf level, then its breeding grounds would be lost, and then the species would be lost, right? And that was specifically one area that was meant to be protected when the federal government set this aside. So a rancher that was some distance away was using groundwater, and this is in Nevada, using groundwater for their agriculture purposes. And the United States went and sued and said, no, you have to stop taking that groundwater because the groundwater that you're taking is impacting the level in Devil's Hole, the lake level in Devil's Hole, and impacting the federal reserve water rights. And the United States said, yes, that's right. The Supreme Court said, to the extent that your groundwater withdrawals are impacting surface water or federal reserve water rights, and you can also have federal reserve water rights to groundwater as well, that is contrary to this federal reserve right and ordered the pumping to cease. Interestingly, they didn't say there is a specific amount of acre feet necessary for Devil's Hole. Instead, they installed a brass plaque in the lake, and they said the groundwater that is that it's the pupfish. He doesn't like didn't like being called ugly, I guess. So they installed a brass plaque, and they said, to the extent groundwater pumping makes the water in Devil's Hole fall below that plaque, then that's sort of the enforcement mechanism. Is it? Is it? I'll put it down then. Sorry. Kind of talk with my hands. Nope, not that. Okay. Okay. Well, I'll try to power through it if you guys can. Is that worse? Okay. Okay. You guys tell me if it's insufferable or if it's just me. So another step back. So now we know how when you have reserved water rights for federal law, how they impact those state-based water rights. Now we have another question of, well, these are federal reserved water rights. We have federal courts for federal law, state law. So what the heck are you doing in state court for the adjudication? And the answer is because of this gentleman, Pat McCarran. If you've ever flown into Las Vegas, it's named after the same gentleman. And he included an appropriation, an amendment that said a state is quantifying water rights on a particular stretch of river, that those federal reserved water rights that are also on that same stretch of river can be heard in the state court. And as Sarah mentioned, this went to the United States Supreme Court in the case of Arizona, and the court said, yes, the state can hear these Federal Reserve water rights in state court in a proceeding with all water rights users together, an inter se proceeding, as they said. And they can do that so long as the state adjudications are adequate to quantify the rights at issue in the federal suits. So that's sort of an ongoing question as I talk to folks. Of course, we're in year 45 and counting of the general stream adjudication for the Gila River. And the question of adequacy is a good one. And don't know where we're at with it, but it's something that's always sort of hanging under the adjudication. Because if the state court is inadequate, then the result would then be to go to federal court, which also maintains jurisdiction over it. So that's an ongoing question, but we are where we are, which is in state court. The Yavapai Apache Nation, just like everyone else who's asserting a water right in the general stream adjudication, had to do so on state forms. And so this is one of the claims of the Yavapai Apache Nation in the Gila River General Stream Adjudication. The United States, as trustee for the Yavapai Apache Nation, has also asserted a water rights claim. We're in the process of updating both of them. But this original one includes a claim for 6,283 acre-feet of water, including in-stream flows for the nation. And as I said, we're updating those. But this gets to sort of the bigger question. The Yavapai Apache Nation, every federal Indian tribe that does not have a water rights settlement and is anywhere near surface water has to come to a decision on whether to settle those claims, right? These are litigation claims. We're in a litigation. Whether to settle that litigation and what that would mean for that tribe in particular, right? Because you're giving up whatever assertion you can make in that litigation. And so for different tribes, there's different issues at stake, and each tribe is going to make its own decision. For some, the policy considerations that the state of Arizona requires are not acceptable right now. For some, it's they're willing to do so if it means a certainty in their water future. The Yavapai Apache Nation has entered into settlement discussions. They've been going on for some time. Part of that means having a federal water rights team, which the nation has. And so that pulls representatives for the different federal interests in the area. So there's a Forest Service member on the team, there's a National Park Service member on the team, reclamation, etc. And it also means discussing with neighboring communities about what a settlement could look like and what a settlement might mean for the nation in particular. But each settlement, you always sort of had to pull in all those parties to have the conversation about what that settlement, what the future of water is going to look like for both for the tribe and for the neighboring communities. And in particular here in the Verde Valley, where the nation is in the middle of all of these communities, right? There has to be partnership. And I'll talk a little bit about that. Just real quickly, though, there are always challenges associated with settlements. And one is that negotiations can be difficult. They can take a long time. Water is hard generally. Federal Indian law is hard generally, so there are just difficult things to work through in these settlements. And as Sarah mentioned, congressional approval is required. And just to sort of cross the T on what she said, there have only been 32 Indian water rights settlements in the country. There are more than 500 federally recognized tribes. So that there are only 32 settlements of those water rights claims is pretty, it's a rare thing generally. And Arizona has about a third of them. Here's a list of all of the tribes in Arizona and whether they have water rights settlements or decreed rights. And then on the right, you'll see tribes that either have partial settlements or don't have settlements. I'll note on decreed rights, there are 4 tribes along the Colorado River. When Arizona and California sued each other in the case appropriately named Arizona v. California, the Supreme Court also decreed not just the water rights for the state of Arizona and the state of California, but also the water rights for the 4 tribes that are along the Colorado River and below Hoover Dam. So it didn't include Navajo, Hopi, San Juan Southern Paiute that are before they get to Hoover Dam, but it did include Kachan, Cocopah, Fort Mojave, and Colorado River Indian tribes. So they have decreed rights. They didn't go through a settlement. They don't have, for instance, congressional authority to use water off reservation and those other things you tend to think about with settled tribes. But they do have decreed rights on the Colorado River. You'll see Yavapai Apache Nation does not have a water rights settlement, neither does Tonto Apache tribe. And some tribes have partial settlements to their water rights. Wallapai tribe is currently trying to get the last part of their water rights settlement through Congress. So for the Yavapai Apache Nation, there are really 2 goals for its water future. One is to provide enough water for their permanent tribal homeland. And they want to do that in a way that means no additional hits on the river, no more water taken out of the river than is going out right now. And so we're working through a bunch of mechanisms to make sure that that happens. And then the second goal, and I think it's really a goal that's shared broadly by the community, and that's to ensure a flowing Verde River. It's very clearly the case that the Verde Valley is that the Verde River flowing through the valley is essential, right? The Yavapai Apache Nation hosted the state legislature up last year, I think, and had a big meeting like this where people could talk about it. And it really was everybody who came up to the microphone said, we need a flowing Verde River. We need to ensure that the river flows, not just for property values, but for economic development. And the nation couldn't agree more on that. So the benefit of a water rights settlement can be sort of multiple layers on layers. Not only does it get the nation out of the adjudication and give certainty to the nation and the communities around it about what the water future for the nation will be, but it also has the opportunity to bring down resources, potentially federal resources, to help ensure that water future can happen. And so there's an opportunity here to look for sort of win-wins in a negotiated settlement for the neighboring communities and also for the nation. And that's really what we're working towards. Because as the chairwoman of Yavapai Apache Nation says frequently, and I'm sure many of you have heard it, the Yavapai Apache Nation will only be successful if its neighboring communities are successful as well. And so the water rights settlement is one way that the nation can help make sure that that is the case. So with that, I will run away from the speaker and leave you just with a sentence from a Yavapai tribal elder that I think really sums up water in Arizona, and particularly in the Verde Valley, that as long as the river flows, life will be good. And that's what the nation wants to see happen, and that's what we'll be working towards. So I'm happy to talk with any of you or answer any questions you might have about that. Hopefully it was helpful to give some context to federal Indian law and federal water rights claims. So I will now stop angering the speaker.